Hi everyone, in this week's dispatch video we are discussing the impact of the Employment Rights Act on probationary periods under the contract of employment, essentially from the 1st of January 2027 with new employees. What do we do? Some employers, very limited number, actually choose not to have a probationary period at all. Whether you have one or not, that must be written into the employment contract. That is a requirement from April 2020. The difficulty arises where probationary periods are 6 months or longer under current contracts, because the risk is that by operating a probationary clause in that way, any review that is conducted at the end of it could be happening at a time where from January next year an employee will have qualifying service for unfair dismissal. Traditionally, probationary periods were in play to allow a period of time to monitor a new employee and for them to have a target to work towards to impress the employer. But it would also lead to a relatively low risk dismissal in circumstances where that probationary period was not successful, because dismissal at the end of the period would not allow an employee to qualify for unfair dismissal rights. Now, if that review takes place at or after 6 months, typically the employee will have the right, unless they've committed an act of gross misconduct which allowed termination without notice at 6 months, an employee will qualify for unfair dismissal rights. So what do we do in those circumstances? We could keep the probationary period at 6 months or longer, but if we are looking seriously at dismissal, we could dismiss during that probationary period, and all contracts will contain clauses which allow an earlier termination right. My advice is to reduce that probationary period to 3 months, with the right to extend up to a further 3 months. That will allow a formal review to take place at the end of the 3-month period, but it will then allow a review at 4 months, a review at 5 months. But what we must do is ensure that any final review takes place well in advance of that 6-month anniversary. And this is because under the Employment Rights Act, unless there is a dismissal by reason of gross misconduct, an employee can add their statutory week's notice onto their length of service. So if we dismiss somebody the day before they reach 6 months service, the employee has actually accrued unfair dismissal rights at that point, because they're entitled to add the statutory week's notice on, whether it's worked or paid in lieu. They will have that right. That also brings into play, of course, the requirement to ensure that there is a significant paper trail during the probationary period. There is a significant improvement in many cases in terms of active management of that probationary period, and in respect of any extension, that we diarise the review dates and don't miss them. We can't retrospectively undertake a probationary review meeting after the 6-month period to prevent an employee from qualifying for unfair dismissal rights. The only other point I would make in relation to probationary periods is that often a number of benefits are linked to the successful completion of that period. So, for example, an employee will be provided with life assurance, private health insurance, they will qualify for company sick pay or enhanced maternity benefits. There is nothing wrong with still linking contractual benefits to either the completion of the probationary period or completion of a certain amount of service with the employer, which may well exceed 6 months. Lots of changes coming in under the Employment Rights Act. If you need any advice on this area or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.